fundamental right to fair hearing guaranteed under Chapter 4 of the National Constitution, as well as the application and operation of the limitation laws of Akwa Ibom State, which is an area in which the law is to some extent recondite. Council argued that the constitutional right to fair hearing or fair trial is a right granted under Chapter 4 of the National Constitution. That in the case of Hudson Graphics Arts and NDIC, it was held that by the stipulation of Section 241D of the National Constitution, a person can appeal as of right where he contends that any of the provisions of Chapter 5.4 of the National Constitution is being or is likely to be contravened. The court held further that since ground one of the grounds of appeal complains about lack of fair hearing, no leave is required as an appeal lies as of right in respect of such a ground of appeal. Council cited the cases of South Atlantic Petroleum Limited and Ministry of Petroleum Resources, Dangote and African Petroleum. Ghana Senior Council reiterated that the issues raised by the grounds of appeal together with the relief sought from the Court of Appeal are so intricately connected to the issue raised in this suit that any judgment entered in favor of the claimant by this honorable court will impact and conflict with any judgment entered in favor of the applicant at the Court of Appeal, thereby rendering the eventual decision of the Court of Appeal negatory. Council refer to Order 4 Rule 11 of the Court of Appeal rules, which provides that, and I quote, after an appeal has been entered and until it is finally disposed of, the Court of Appeal shall be seized of the whole proceedings as between the parties thereto on court. Ghana Senior Council further submitted that the applicant has shown that there are sufficient grounds for the court to grant stay of proceedings. Ghana Senior Council also reiterated the principles stated in Nika Fishing Company and Labina Co. that, and I quote, an applicant has no duty to prove at that stage that the appeal will succeed once he shows that the appeal is arguable and there are chances of success. An application for a stay of proceedings could be granted on court. In conclusion, the Ghana Senior Council stated that this is an appropriate instance for a favorable exercise of the court's discretion, as the applicant has provided the requisite materials for grant of this application. Council therefore urge the court to grant this application in the interest of justice. Claimant's written address in opposition to the motion for stay of proceedings. In opposition to the application, counsel on behalf of the claimants/respondents filed a written address on 4th July 2025, where a loan issue for termination was submitted to it, and I quote, whether having regards to the circumstances of this case, the applicant is entitled to the prayer sought in the motion before the court, on court. Council submitted that an applicant for stay of proceedings before this honorable court is enjoined to comply holistically with the provisions of Order 64, Rule 1 and 2 of the rules of this honorable court. That a careful look at the affidavit and provisions of this rule on the requirement for the grant of stay of proceedings shows that the applicant failed to comply with the requirements for the grant of the application. Council first submitted that leave has not been granted by the Court of Appeal to enable the applicant to file a notice of appeal, let alone to comply and transmit the records of appeal. Council referred to Order 64, Rule 14E, that until leave is granted by the Court of Appeal, this honorable court cannot consider the application for stay of proceedings. Council contended that the applicant did not avert his mind to Order 64, Rule 14 of the rules of this court, where the use of the word shall in the order connotes that the conditions laid down are mandatory. Council refer to the case of Mr. Dele Odusoti and Dr. Martins Temitayo. Council continued that rules of court are meant to be obeyed. Council referred the court to the case of Dare and FRN and maintained that the applicant has failed to comply with the rules of this court, entitling him to the grant of the application, as the application before this court is hasty and premature at this stage. That the applicant is required to apply for stay of proceedings after leave has been granted by the Court of Appeal. Council further contended that the court, in exercising its discretionary powers, grant application for stay of proceedings is guided by the clear provisions of Order 64, Rule 14 of the rules of this court. That the rules of this honorable court are subsidiary legislation, deriving its existence from the ground norm made pursuant to the powers conferred on the President of the National Industrial Court by the Constitution. Council refer the court to Section 2541 of the National Constitution. To the first submission of counsel that the argument of the applicant the first submission of counsel that the argument of the applicant that our constitutional right to fair hearing has been breached, hence does not require the leave of the court to appeal is misconceived. That there was no issue of fair hearing before the court. The defendant applicant did not even file a counter affidavit to substantive suit before the court. Rather, it was a plenary objection that was filed, and so there is no way the applicant could allege breach of fair hearing. It is the further argument of counsel that this honorable court lacks the capacity to consider the grounds of appeal as contained in the written address in support of the motion. It is the Court of Appeal who will grant the leave. That is the Court of Appeal who will grant the leave that to satisfy itself that there are arguable grounds. Upon that finding, the court will then consider stay of further proceedings. Counsel was also argued that the issue of jurisdiction at interlocutory appeal can be raised along with the appeal against the main judgment. Counsel cited the case of NICE and Akin Insurance Company Limited. In conclusion, counsel states that on the strength of their argument conveyed hearing, this honorable court ought to refuse the application of the applicant in that the applicant has failed to comply with Order 64(1)(e) of the rules of this court, that by Order 64 Rule 14(3), an appeal to the Court of Appeal from the decision of this court shall not operate as a stay of execution, judgment, ruling, or proceedings of the court. Counsel urged the court to refuse the application with cost. Applicants reply on points of law. Lana Senior Counsel for the applicant reiterated that ground one of the applicant's ground of appeal challenges the lower court's breach of the applicant's right to fair hearing. And fair hearing is a question of fundamental right as contained in Chapter 4 of the National Constitution. Hence, the applicant notice of appeal does not require the leave of the court. Counsel referred to the case of CBN and Opanachi and Section 243, sub 2 of the National Constitution. That the respondent's argument that the applicant failed to comply with Order 64 Rules 1 and 2 because the applicant failed to first seek the leave of the Court of Appeal is misconceived. That the applicant has satisfied the requirements stipulated under Order 64 Rule 14, which only mandates leave to be sought where all the grounds of appeal require leave of the Court of Appeal. In this case, the notice of appeal is competent having contained grounds that do not require leave to appeal. Counsel urged the court to discountenance the respondent's argument for being frivolous, misconceived, and flawed in law. Counsel also urged the court to grant the applicant's stay of proceedings for being meritorious and having sound legal basis. I have carefully studied the application and the counter affidavit file, as well as the submissions of learned counsel for the parties. The issue I will consider is whether the defendant applicant is entitled to the grant of this application. I find it imperative to refer to Order 64 Rules 8, 9, 10 of the 2017 rules of this code, which is stated as follows, and I quote, Order 64 Rule 8, an application made to the court for a stay of execution or proceedings under any judgment or decision appealed against shall be made by a motion on notice supported by affidavit stating forth the grounds upon which a stay of execution or proceeding is sought. Number 2, notwithstanding anything to the contrary, mere filing of an application for a stay shall not operate as a stay of proceedings or execution. Number 3, furthermore, the mere filing of an application simpliciter shall not be sufficient for the court to grant a stay of execution of the court, or b, stay of proceedings before the court, provided that where an appeal has been filed and all records of proceedings have been transmitted and an appeal has been entered, that is to say that the appeal has been issued a number, the court may, on sufficient grounds, stay the execution of the judgment or the proceedings upon which the appeal has been entered. Provided further that in an application seeking for the stay of the execution of the judgment of the court pending appeal, where an appeal has been entered in line with the provisions of this order, the court may stay the execution of the judgment on the condition that the judgment date, while the issue is monetary, is paid into an interest-yielding account with the name, the Chief Registrar National Industrial Court, pending the hearing and determination of the appeal. 4. While the issue on which the application for stay of execution is made is not monetary, and an appeal has been entered, the court may grant the application for stay of execution of the judgment or stay of proceedings on the condition that the status quo ante, as from the date of judgment, be maintained pending the hearing and determination of the appeal. 9. An applicant for stay of execution of the judgment or for stay of proceedings under this order shall compile the records of appeal within 21 days from the date of filing a notice of appeal. And while the record is not so compiled, the respondent may apply to strike out the application or discharge the order where already granted. Number 10, the court may make or refuse an order for stay of execution or proceedings on court. Looking at the procedure presented before this court, it is clear that the applicant did not seek the leave of the Court of Appeal against the decision of this court. However, the applicant contended that whenever a ground of appeal raises an issue of fair hearing, leave is not required. But it is obvious that it is only in the applicant's first ground of appeal out of 5 that the issue of fair hearing is raised. It therefore means that leave is still required before the Court of Appeal to argue the applicant's other grounds of appeal. In the case of Skybank and EU, it was held that a party who is aggrieved by the decision of this court in civil matters, as in this case, can exercise his right of appeal with leave, can exercise his right of appeal with the leave of the Court of Appeal. But an appeal shall only lie from the decision of this court as of right to the Court of Appeal on questions of fundamental right, as contained in Chapter 4 of the 1999 Constitution. See Section 243 sub 2 of the 1999 Constitution. It means, therefore, that the lack of necessary leave for most grounds of the applicant's grounds of appeal shows that the applicant has only one valid ground of appeal, and it may need the leave of the Court of Appeal for the other grounds. And this casts serious doubts on the validity of the appeal and weakening the foundation of the application for stay. Going by the decision of the Supreme Court in Skybank and EU and Section 243 sub 2 of the 1999 Constitution, it is tried that while the leave of court is required for the exercise of a right of appeal, obtaining such leave becomes a condition precedent to exercise of that right of appeal, and failure to obtain leave where it is required will render the appeal incompetent, as the court will be divested of any jurisdiction to entertain the matter. See the case of Fan and Boycotting Limited. In Mobile Producing Nigeria Limited and Ayeni, it was stated that an appeal must have been filed before a court is called upon to stay proceedings in the matter. It is a well-established principle of law that a pending appeal is a condition precedent to stay of proceedings. This was also held in the case of Omolulo and Aderinokun. Therefore, the effect of non-existence of a pending appeal as captured in the Court of Appeal in the case of Ogunyemi is that an application for stay of proceedings pending determination of appeal cannot be of any moment. A valid and subsisting appeal is a sine qua non for the application for stay of proceedings. In any case, it is tried that an appeal does not ipso facto operate as stay of execution or proceedings, and it's not enough reason per se to grant a stay. See Order 64, Rule 14.3 of the rules of this court, and the case of Vaswani Trading Company and Savala. Equally, the courts have over the years laid down the principles upon which an application for stay of proceedings could be granted. Some of the guiding principles laid down by the court in granting or refusing stay of proceedings include the following. Number one, there must be a valid and competent pending appeal. Where there is no competent pending appeal, there is both a law and in fact nothing to stay. The court will therefore not consider an application for stay of proceeding in respect of an invalid appeal. Number two, the application for stay will be granted where special and exceptional circumstances exist. Number three, the court will consider the competing right of both applicant and respondent to justice. Number four, the court of law will be most reluctant to grant an application for stay of proceedings if it will cause greater hardship than if the application is refused. The question of hardship is a matter of fact, which can be decided from the competing affidavit evidence. The pending appeal must be the pending appeal must be arguable. This is decided by considering the grounds of appeal filed. Number six, the court of law will grant stay of proceedings in order to preserve res for the purpose of ensuring that the appeal, if successful, is not rendered nugatory, while the issue of the decision is involved in the pending appeal. Number seven, while an application for stay of proceeding will unnecessarily delay any proceedings, it will not be granted. Number eight, the court has a discretionary power to exercise in a matter. Number eight, the court has a discretionary power to exercise in a matter, and it must be exercised judicially and judiciously. See the case of National Bank of Nigeria Limited and NET, Nika and Lavina, Paniki Toby JS. It is settled law that a stay of proceeding will only be granted by the court if it satisfies that there are special or exceptional circumstances to warrant doing so. The reason being that the law is the decision of the court of law is presumed to be correct and rightly given until contrary is proven. And again, the courts have refused to make it a practice of depriving a successful litigant of the fruits of his success in court. See the case of Integrated Nigeria Limited and Zuma Fund Limited. The grant of a stay of proceeding or execution is a matter of discretion for the court, and any action or conduct which tends to stifle the exercise of such discretion must be frowned upon by the court. See the case of Kigo and Holman Bros Limited. It can be observed that the applicant in this case has taken steps towards pursuing the appeal by costing to compile and transmit the records of appeal, which is a factor that will make the court exercise its discretion in favor of the applicant. See the case of Vaswana and Sabla. However, it is an established fact from the record of the court that the respondent filed this case against the applicant on 12 July 2024 by way of originating summons, but the applicant only filed a notice of objection to the court's jurisdiction without filing a counter affidavit or originating summons. The objection was then argued and resolved against the applicant on 18 February 2025. Then the applicant again filed an appeal against the ruling on the objection and also brought the instant application. I expected that the applicant would have filed his counter affidavit alongside the notice of objection to enable the court to determine everything together, either way, so that in case the matter gets to the Court of Appeal, it will also be able to determine both the substantive case and the objection altogether without having to hear the issue in piecemeal, which is also frowned upon by the Court of Appeal. Similarly, I cannot feel ignorance of the fact that our appellate courts are so overwhelmed by a considerable number of appeals from every part of this country, which has significantly caused delays in hearing appeals filed at the appellate courts. It's imperative to take judicial notice of the significant backlog and delays in appellate courts. See Section 12 of the Evidence Act. Additionally, even though the applicant has compiled and transmitted the records of appeal and raised an arguable issue of fair hearing as well in its grounds of appeal, which are one of the bases for the grant of stay, however, mere raising an arguable issue of fair hearing is not a conclusive reason to grant an application for a stay of proceedings pending appeal. It is not the law that once an issue of law is raised, the court must grant a stay of proceedings pending determination of the appeal. still depends on the discretion of the court. See the case of Nigeria Industrial Limited and Oladehi, Young Shall Grow Motors Limited and Afolabi. In the light of the above, therefore, I find that granting stay of proceeding in circumstances of this case will unnecessarily delay substantive proceeding, which will only be heard on affidavit evidence. I'm therefore unable to tilt my mind in exercising my discretion in favor of the applicant, especially when considering the competing right of the parties, as the applicant application falls short of some of the factors to be considered by the court in granting an order of stay of proceedings as provided by our extant rules of court and the case law. Considering the fact and circumstances of this case, I consider the applicant's application for stay as an obstacle to delay the hearing on the substantive matter, and the application is accordingly dismissed. Yes, Mr. Vurasi.
Ruling of the court is for us to take a date for hearing of the originating summons.
Okay.
Yes, my lord.
Lanesik.
Yes, my lord. I thank my lord for the very deep and well-considered ruling.
Yes, thank you.
We are well guided by my lord.
Thank you so much.
Yes.
My lord,
going to the merit of this case, we feel that this is a matter that is not suitable for an originating summons proceedings because it's a matter that relates to entitlements of the claimants.
Yes.
And it will require
oral evidence,
giving of oral evidence in this matter. There will be substantial disputes of fact, which my lord would not be able to resolve.
But how do you know that the matter requires filing of oral evidence?
My lord, even on the strength of
But let's say you don't yet have your counter affidavit. You didn't controvert any of the facts averred
that is because we felt the matter was statute barred, and so there was really no.
So what do you want now?
My lord, what we would want, the application would like to make orally, or if my lord so direct, we can bring a formal application, is that this matter should be converted to complaint. Yes,
but the thing is no.
But who is talking? Is it Mr. Brasi?
Mr. Vorasi, you're not the judge. I'm addressing the court, please.
Yes, addressing the court, yes.
Yes.
You don't have to interject.
Thank you, my lord.
Yes, what I was trying to say is that the defendant has not yet filed his counter affidavit to the originating summons. And I thought it is when a counter is filed that the defendant will now start to raise the issue of hostile nature of the proceedings, that it needs an oral evidence to resolve the dispute instead of coming by of originating summons. And I also thought that you will have included that in your earlier objection, so that everything will be heard. But and you can still file your counter alongside the application to call for oral evidence, so that the court can hear everything together, isn't it?
Well, my lord, if the court, our application is that
instead of taking the applications in piecemeal,
Yes, my lord.
You can file your counter alongside the application to call oral evidence, so that the court can hear everything together. Because one thing that I've observed from this case, Mr. Lano Essian, is that from the declaration sought by the
claimants.
Yes, it's like they're asking for declaratory orders, isn't it?
Yeah, but beyond declaratory orders, they're asking for executory order, which is orders, specific orders.
Yes. What are the executory orders?
Well, the counsel to the claimant is here. I don't have the file with me, but
the file.
Yeah, perhaps he can guide us to the reliefs they are claiming. It's not just declaratory orders.
Okay.
Mr. Vorasi, can you guide the courts?
I think there are some. Okay, let me even check the.
My lord.
No, let me even check.
As the court pleases.
Mr. Burasi, what are the orders?
My lord, number one, okay, it's purely declaratory, my lord. Number one is to be entitled to be reinstated to 100% of their annual pensions from the present 75%, effective from the first day of February 2006 and first day of February 2014. Then secondly, my lord, payment of all arrears and all shortfalls of 25% of their pensions by the defendant from first day of February 2006 and first day of February 2014, so when they are fully reinstated to 100%. My lord, that's just what we are claiming.
That is not declaratory.
It's declaratory, my lord.
Yes, I'm trying to get the.
Well, Lord, I don't know if my learned friend is reading from his originating summons. What I have here, I have a soft copy.
Yes, let me say, I'm reading from there.
So if you read your originating summons.
Okay, what is saying? I think there are two reliefs.
Yes, but my lord, the reliefs are not even couched as declaratory declarations.
Yes.
According to the originating summons I am looking at.
Yes.
It says
entitled to be reinstated to 100% of their annual pensions, isn't it?
Yes, my lord. So it's not declaratory.
Yes, but all what I'm trying to say, Lana Essian, is that even when this matter is hard on its merits, and it happens to be not in favor of the defendant, I'm sure once the defendant appeals, satisfy the requirements of the appeal, nothing will stop the court from granting a stay of execution in favor of the defendant. If you can recall, one of the reasons that I refuse this application is that there is substantive matter still pending. And when I grant the order for stay, it will delay this, the hearing of substantive case. But once the issue, is hard on its merit, and it turns out to be not in favor of the defendant, when the defendant appeals, nothing will stop the court from granting stay once the defendant has satisfied the requirements. So that's why I'm advising that let us hear the case on its merit. because when you hear it when it's heard on its merit, we don't even know which way it will go. If it goes against the defendant, and I'm sure that the defendant is going to appeal, when the defendant satisfies all the requirements, that's nothing was, especially when the records of appeal are compiled and transmitted. I don't think that the an order of education will not be granted in favor of the defendant. That's just
my lord, we agree with my lord. My lord,
yes,
we are willing to for this matter to be heard.
Yes, because if I'm repeating that the main reason that I refuse the stay is that there is a pending substantive matter.
That is correct.
Yeah, which staying, which will be affected when proceedings is stayed. If not, you have almost satisfied all the record. You have compared the record. You have it is transmitted. Appeal number given. You understand?
Yes,
but the thing is that it's just an interlocutory appeal. When you go there, they even ask you to come back. You understand, and get done with the whole matter. Then, if you're not satisfied, you can go there and lump everything there. So I did that to save, time and everything.
Yes, my lord, we are not quarreling with my lord's ruling. We are moving on away from the ruling. We are saying, okay, we are at the stage where this matter should be heard.
Yes.
The question now is, should it be heard on the originating summons, or should it be converted to a complaint so that it will be heard on the complaint? That is the issue now.
No, as far as I'm concerned, no complaint is filed. The applicants or claimants have just filed an originating summons. You understand? They want their case to be heard on originating summons. It's not for the court to. It's not for me to say that this matter should convert to to pleadings.
No, my lord, that is why I made an oral application that my lord should consider making an order.
No.
Yes, my lord.
I cannot do that like I said.
Very well. My lord, in that case, we will bring a formal application. My lord, I'm saying this so that when we bring the application, it will not look as if we have brought another application. We are taking counsel by surprise.
Nobody will stop you from bringing an application again. But what I'm trying to say is that anything that you file, we are going to adjourn this matter for hearing of substantive matter. Even if there is any objection again, we'll take it alongside, substantive originating summons. So that will just,
my lord, it will not be tidy to take an application to convert the originating summons along with the originating summons.
I think that nothing stop the court from doing that. There's nothing to stop because it's a trend. The Supreme Court has many times said that any application, whether on jurisdiction or on anything, can be taken alongside the substantive matter. It's a tried issue, Mr. Lanesian.
The trend that I know, my lord, is an objection to jurisdiction can be taken along with the substantive matter. And it is already enshrined in my lord's rules, the rules of this court, that it can be done in that manner.
It can be done in any manner, whether it's an application to jurisdiction, whether it's an application on conversion of the received summons to pleadings. It's still the same thing. When a counter, because sometimes if you don't even have your counter, then how can the court even, because when we are asking the court to call for oral evidence, you understand?
Yes.
Because it's only going to look at the processes filed by the claimant. Because the defendant doesn't have a counter affidavit, to even contest the affidavit in support of the originating summons.
As the court pleases. My lord, we will bring the application. I will support it with the necessary documentation that we.
What I'm saying is that if you are bringing the application, you should also file your counter so that everything will be had together. whatever the court, the ruling of the court, if it's against the defendant still, still has a right to go on appeal about the issue. When you go to the court of appeal, you can consolidate all the appeals. Your appeal on the objection, your appeal on the, assuming that you overrule on the issue of calling of oral evidence, you can also put that one. Then you can also appeal on the issue of the substantive matter. You can have 3 appeals, consolidate the 3 appeals at the court of appeal. That in case it's not, in your favor. In case the 2 issues that you will raise will not be in your favor, you can lump all of them there. And I'm sure even the court of appeal, will be happy about that. Instead of taking, one application, coming back, take another one again, come back, take another one again. Let's do everything together so that number 1, we will reduce our docket here. Number 2, even the court of appeal will be happy to have all the appeals consolidated. Yes. Yes, that's just my...
We'll take a date.
Yes.
The date we'll take will be for the 2 matters, my lord, because I assume that the same ruling applies to the second matter. So there's no need for my lord to go through the trouble of reading the second ruling.
Yes, same ruling. Just the names of the parties that...
Well, may we be guided by date?
It has to be in March. Registrar.
Yes,
so, okay, let me
yes,
hear
my lord.
Let me hear Mr. Burasi. Yes, Mr. Burasi.
Yes, my lord, as to the dates. Hello, my
lord.
No,
about what Lionel SAN has said, because you are trying to interject when he was speaking.
Okay, my lord, I will say that this matter was brought by way of originating summons. And by right, my lord, we are supposed to take everything together. So if Lionel SAN intends to still file another motion, my lord, let it be filed alongside with the counter affidavit. So on the date of hearing, we'll take everything together so as not to cause any delay. That's just what I want to add, my lord.
Okay.
Yes, as the court pleases.
Okay. So, Mr. Okon, dates?
Lord, 2nd of March. 2nd March.
Okay, is that okay?
Lord, the 2nd and 3rd of March are not convenient.
So which date is convenient to you?
Any other day during that week.
Okay, so Mr. Okon, which other date again?
4th of March.
4th is convenient. 4th and 5th are convenient.
My lord, 4th is convenient to me.
Okay.
4th of March is convenient, my lord. Yes.
So, given the circumstance, case is adjourned to the 4th of March 2025. Sorry, 2026 for hearing of the substantive matter alongside any other application that might have been filed.
As the court pleases.
Yes.
As the court pleases, my lord, just to be sure that my lord mentioned 4th of March.
Yes, yes, Mr. Wilson. 4 March.
As the court pleases.
That's 4/3/2026.
Very well, my lord.
Thank you.
Very well. My lord, may I use the opportunity to wish my lord a restful holiday, Christmas holiday?
Thank you so much, Mr. Wilson.
Yes.
Thank you. Same to you.
Yes, my lord. Very grateful, my lord.
We attended
and a happy new year in advance.
in advance. Thank you so much. Same to you.
Very well, my lord.
We attended all judges conference last month.
As the court pleases.
PJ Lagos, PJ of the Court of Appeal Lagos Division.
Very well.
Just name part. I was talking about this issue of stay of proceedings pending an interlocutory appeal.
Yes.
She said what she normally does is to, ask the counsel to go back to the trial court and conclude the main matter. Yes, and then whatever it is, they can come back and lump it along with the interlocutory appeal, taking into consideration that when you are filing an appeal, you have to do it within 14 days. If not, you seek for the leave. So she said, that's what they are doing in Lagos.
Yes.
That's what she said. So I just took that hint and said, okay, let us also do that in this case.
That's to align with the thinking of the
Court
of appeal.
yes. Because if it were a final judgment, once the record is transmitted, nothing will stop us from granting stay. Yes. Because it's a final judgment. We shouldn't do anything that should prejudice the outcome of the appeal. But this is interlocutory. Yes, this interlocutory. Yes. Who even knows the outcome of the main case?
Exactly. Nobody knows.
Nobody knows.
So I may end up not being the appellant.
You see.
So I shouldn't fear.
No. Nobody knows.
Yes.
Nobody knows. Yes. It's okay.
We appreciate that, my lord.
Thank you.
Very well, my lord.
Thank you.
Thank you, my lord.
Okay, thank you.
Yeah. My lord, I'll seek my lord's indulgence to sign out from the meeting.
Granted. Thank you.
To log out. Very well, my lord. Thank you. Yes.
Okay. Okay, Mr. Burasi, thank you too. So, Okon.
Yes, my lord.
The second case is the
5 Achim Nathaniel.
Thank
Okay.
you, my lord. We are grateful. We are grateful, my lord. I'll lock out too.
Okay, thank you, Mr. Burasi.
My lord, permission to call the next matter.
Okay, thank you.
All right. Suit number NICNU Y35 2022 between Achim Nathaniel and Lineary Consultancy and Construction Company Limited. Mr. Pyro Alafranc Juno. All parties are absent in court.
Okay. Mr. TN. Yes.
Yes, my lord.
Yes.
Yes, my lord. May it please this honorable court.
Yes.
To hear T and Boelo.
Huh?
Appearing T
T
and
and
Boelo. Yes.
so the G is silent.
The T is always there's a T and Boelo as in my initials, sir.
Yes, so I'm saying that the G, GBO.
No, it's T.
Yes,
N.
T N initials, then GBOE, LO.
Yes.
Isn't it H?
LOH. Yes, my lord. Yes.
Boilo.
LOH.
Boilo.
My lord. Yes, Boelo. Yes, my lord. Yes. Yes, my lord.
So I'm saying that
Yes,
the
my
G,
lord.
okay,
appearing with AS Igwe.
Igwe.
AS Igwe.
Okay.
Ejire. My lord, Igwe is spelled IGWE hyphen EJIRE. Ejire Square. Means, my lord.
EJI.
RE.
Ejire.
Ejire. Yes, my lord.
Ejire.
My lord, together we both appear for the claimants.
Okay. Thank you.
You're welcome, my lord.
What about Mr. Augustine? Mr. Lawrence John, counsel for the defendant. Yes. Is he in court?
Yes, he's just very relaxed over there, my lord.
Okay. But I can't see him.
I'm seeing him right there watching at us.
Okay. Is it Mr. Lawrence or Mr. Asuko? Is it Lawrence or Asuko?
No, not Asuko, my lord. What's that his name again? My lord is Mr. What do you call this nonsense? But he's just watching at us. I don't know what is whether he's having a challenge. Yes, my lord, Mr. Lawrence John, my lord.
Lawrence or Asuko?
Yes.
It's Lawrence?
His mouth is moving, my lord. It appears he is having technical challenge.
My lord?
Yes.
Can my lord hear me?
Yes, I can hear you.
I'm Lawrence John, my lord.
Okay, thank you.
Yes, I'm not in court. I'm in Abuja.
It's okay, no problem.
Yes, my lord.
Lawrence.
John.
Lawrence John, for the defendants.
For the defendants.
Okay. Thank you.
Maybe not. I can't really way they talk to traditional family.
So this is my ruling.
As a complicit.
The claimant by a general form of complaint filed on 29th of September 2022 sued the defendant and prayed for the following reliefs. An order of this honorable court directing the defendant jointly and severally to pay to the claimant an outstanding balance of €13,500 representing the shortfall in the claimant's salary, medical, and pension allowances from the months of August 2018 to November 2018 within 30 days from the date of judgment. Number 2, an order of this honorable court directing the defendant jointly and severally to pay the claimant within 30 days from the date of the judgment the sum of 76,500 euro, representing claimants on paid basic salary, medical, and pension allowances for 9 months, which accrued before 1st December, before first defendant acting in concert with the second and third defendants, purportedly and wrongfully terminated claimant's appointment via email. Number C, an order of this honorable court directing the defendant jointly and severally to pay the sum of 16,763,000 naira, representing 12,000 euro for every 3 months in naira, for every 3 months in naira, equivalent for a 10-month period at the prevailing foreign exchange conversion rate by Central Bank of Nigeria of 419,000 naira per 1 euro, which is 5 million naira. That is 12,000 euro per every 3 months, pursuant to clause 3, line 9 of the agreement for the months of November, December, January, February, March, April, March, and June, respectively, within 30 days from the date of judgment. Number D, an order of this honorable court directing the defendant jointly and severally to pay to the claimant a total sum of 3,150,000 naira, representing claimant's total local allowance for 9 months, that is from December 2018 to August 2019, which when calculated is 350,000 naira. An order of this honorable court directing the defendant jointly and severally to pay to the claimant a total sum of 482,898 naira, representing shortfalls from claimant's leave allowances, travel expenses, and other incidental bills incurred by the claimant pursuant to clauses 4, 6, and 7 of the aforesaid freelance contract. Number F, a declaration that the claimant is entitled to the sum of 35 million naira as general damages for the breach of the freelance contract agreement between the claimant and the defendant, which has caused claimant severe economic hardship and extreme deprivation as a direct consequence of the aforesaid breach. Number H, an order of this honorable court awarding the sum of 1,500,000 naira as the cost of this action. Number H, an order of this honorable court directing the defendant to pay the judgment sum to the claimant through his solicitors within 30 days from the date of judgment. Number I, an order of this honorable court directing the defendant to pay 12% interest per annum on judgment sum until judgment debt is liquidated. Number J, and any ancillary orders this court may deem necessary to make in the circumstance on court. Upon the death of the claimant, the applicant by a motion on notice dated and filed on 28th of April 2025 praised the court for the following reliefs. Number 1, an order of court granting leave to substitute Mr. Achim Notnagel, now deceased, with Mrs. Sheila Notnagel, who is the lawful wife of the defendant, of the claimant. Number 2, an order of court granting leave to the applicant to file her witness statement on oath, as shown in the proposed witness statement herein annexed and marked exhibit SN1. Number 3, an order deeming the clean copies of the witness statement on oath of Mrs. Sheila Notnagel herewith filed as properly filed and served on payment of requisite fees. And for such further orders or other is on recommending fit to make in the circumstance on court. The motion is supported by a 5-paragraph affidavit deposed to by one Elizabeth Dapper Roland, litigation secretary in the law firm of the council to the applicant. Attached to the affidavit are 3 exhibits. Exhibits SN1 to SN3. The application is also accompanied by a written address. The defendant, upon being served with the application, filed a 7-paragraph counter affidavit deposed to by one Philip Abanyu, Prosecution Secretary in the law firm of the counsel for the defendant. Exhibit A was attached to the counter affidavit. Counsel also filed a written address as a submission in urging the court to dismiss the application. The applicant, in response to the defendant counter affidavit, filed a 6-paragraph further affidavit and reply on points of law with 2 exhibits attached. Exhibit SN4 and 5. In his written address, counsel to the applicant formulated a loan issue for termination to it, and I quote, whether it is in the overall interest of justice to grant the applicant's prayer herein sought, unquote. Counsel answered the above issue in the affirmative and referred the court to orders 17 rules 1 to 8, 12, sub-rule 10 to 13, and Rule 13 of the National Industrial Code Civil Procedure Rules 2017, which empower this court to grant the application so as to dispense of substantial justice in this case. Counsel submitted that the basis of the application is contained in paragraphs 3 sub A to H of the supporting affidavit, which illuminate his submission that the claimant is dead and the cause of this action survives him. Hence, the application to replace the claimant now deceased with the applicant, his lawfully wedded wife, so as to enable this honorable court to determine the subsisting cause of action. Counsel rely on the position of the Court of Appeal per Mukhtar JCA in Yakubu and Ukola. Counsel further submitted that it is settled law that an application of this kind is grantable and can even be brought before judgment is delivered, insofar as it is relevant to the substance of the case, and thus should be determined before judgment. Counsel said the case of Mobile Nigeria Limited and Monopo. Counsel posted that when a party to a suit dies, as in the instance case, he cannot physically take part anymore in the proceedings. His position must necessarily be taken over by the beneficiary who inherits him and who subsequently inherits the litigation. Counsel rely on the case of Rijo, citation supplied. Counsel contended that granting this application will enable this honorable court to arrive at a just, effective, conclusive, and judicious determination of this suit, as well as dispense of social justice to the parties. Counsel referred to the case of Ogumbi and Kosoko, Ekanem and Akpan, that following from the material facts in the supporting affidavit, counsel urged the honorable court to exercise its discretion judiciously in favor of the applicant. Counsel also cited the case of Ogumpehin and Nicholas Ventures. In opposition, counsel to the defendants in his written address formulated 2 issues for termination to it, and I quote. Number 1, whether a person who is not a personal representative of the deceased party can lawfully substitute the party. Number 2, whether a suit can be sustained against a deceased party without substitution, unquote. In arguing issue 1, counsels contended that the claimant cannot lawfully be substituted with Mrs. Sheila Notnagel, not being a personal representative of the claimant. It is trial law, as was held in the Adeosu, that on the death of a sole plaintiff in a pending case, while the cause of action survived the plaintiff, only his legal representatives, vis-a-vis his executor or administrator of his estate, can lawfully substitute the plaintiff. Counsel also cited the case of Ayasan and Sanusi. Counsel also placed reliance on the case of Ugu and Tadi, where a personal representative is defined as the executor or administrator, whether acting with regards to personal property or with regards to real property of the deceased. Counsel also contended that the estate of a deceased person does not evolve automatically to the next of kin, including his wife, even if she is the only surviving spouse, without first obtaining the appropriate instrument of law to administer same. This is because the estate of a deceased person becomes vested in the probate registry until a legal representative, executor, or administrator is appointed. Counsel stated the case of Olora and Adebite, while the Court of Appeal held that on the death of a man, his wife, children, or brothers have no legal right and cannot dispose of his property without letters of administration or will duly admitted to probate. Counsel maintained that with the above authorities, the applicant has not placed anything before this court to convince the court that he has the legal capacity to be the personal representative of Mr. Achim, not Najal, and to authorize her to substitute the claimant in this matter. On issue 2, counsel submitted that the third defendant, being a dead person, has lost the capacity to sue and be sued in an action. Counsel stated the case of SBT and Brimo, Akimbola and International Bank Limited, Ajayi and Ibinohene. Counsel argued that with the above authorities, the third defendant in this matter is dead and no action can be sustained against him. Counsel concluded that this application is incredibly deceitful and therefore incompetent. Counsel urged the court to strike out same. Claimant counsel filed a 6-paragraph further affidavit and reply on points of law dated and filed on 14th July 2025, and also raised another issue for determination to it. Whether this honorable court had the inherent powers to grant applicant prayer in the overall interest of justice. Counsel submitted that the facts, circumstances, and findings of the Court of Appeal in the case of Olora and Adebite, cited by defendant counsel, and the case of Ubuntu and Tabi, Supra, are diametrically different and have no nexus with the instant case. Counsel urged the court to discountenance the cases as inappropriate and as inapplicable to the facts and circumstances of the instant case. Counsel continued that the case of Airtel Networks Limited and George, cited by the defendants, which dealt with the interpretation of Section 3, Sub 1 and 2 and 3 of the Administration of Estate Laws of Lagos State, is a proper guide to the solution of the question raised by the defendant. Counsel reiterated that in the instance case, the applicant has stated that the application for letters of administration is pending at the probate registry, Benue State High Court, and thus urged this honorable court to grant the applicant's application on the strength of Airtel Networks Limited and George, and hear this case on its merit. Counsel argued that the defendants are not members of the family of the deceased claimant, and thus should not be seen as contesting who is the rightful member of the family, saddled with the responsibility of gathering the deceased estate, including his employment benefits under the contract in issue. Moreover, granting this application will enable this honorable court to arrive at a just, effective, conclusive, and judicious determination of this suit, as well as dispense substantial justice to the parties. In conclusion, counsel stated that this application is meritorious and urged the court to discountenance the reliefs herein sought. To countenance the reliefs herein sought. Having considered all the processes filed by the parties and submissions of the respective counsel, it can be observed that the applicant predicated her application for substitution on the demise of the applicant, or on the demise of the claimant, and is of the view that the cause of action in this case survived the claimant, as she can inherit same. But for the defendants, the applicant does not have the legal capacity to be the personal representative of the deceased and substitute him in this matter. In view of the position taken by the parties, this court is now saddled with the responsibility of determining whether from the facts and circumstances of this case, the applicant is entitled to be substituted for the deceased claimant. The courts are enjoyed in considering application for substitution of parties to accord favorable consideration of such applications only in deserving cases and upon the furnishing of the court cogent reasons for the substitution. The apex court in the case of IRRI, APE, and PDP for Muhammad JSC gave an apt exposition of the principles of law applicable to substitution of parties thus, and I quote, I think it is apt for me at this stage to remind my noble laws in a concise manner general principles of law relating to substitution. When one puts something by way of replacement or change of another, whether a person or a thing, that will amount to substitution. The law may permit a person to substitute another in a lawsuit, including appeal, where there is a genuine case of death, bankruptcy, assignment, transmission, or devolution of the interest or liability of a party to a suit or appeal, where the need to substitute is obvious in fact and in law. Where a party is dead, he cannot physically take part anymore in the proceedings. His position must unnecessarily be taken over by the beneficiary who inherits him and which subsequently inherits the litigation. Otherwise, the action for or against the deceased will abate unless appropriate steps are taken to substitute a living person for the deceased. Unquote. C. Ayasan and Sanusi. Defendant contended that the estate of a deceased person does not devolve automatically to the next of kin, including his wife, even though she is the only surviving spouse, without first obtaining the appropriate instrument of law to administer same. However, it appears misconceived to argue that the applicant cannot sue without a letter of resignation, when as shown by the provisions of Order 11 of the rules of this court that she can sue as a beneficiary once she has shown her kinship or relationship with the deceased. In any case, according to the applicant, the application for list of administration is pending at the probate registry of the Benue State High Court. Order 11 of the rules of this court makes copious provisions for the way and manner the entitlement of a deceased employee who died intestate may be claimed. From the provisions of Order 11 Rule 1, a claimant who is a next of kin or beneficiary named in a biodata form of a deceased employee can institute an action to recover the entitlement of the deceased if he proves kinship by first producing certified true copy of employment form / a copy of the employment biodata form of the deceased, which may be in custody of the claimant, or letter of administration from probate registry, or order from customary or Sharia court of appeal, etc. The effect of the above is that the next of kin or beneficiary named in a deceased employee data form, biodata form, will have locus to institute an action claiming for the benefit of the deceased employee, or where he or she is able to show proof of kinship or relationship by any of the above means. A letter of administration is not the only means through which such a claimant can acquire locus standi to sue. Besides, the Court of Appeal in the case of Majomi and Honorable Minister FCT, Pa Mustafa JCA, has held that even where letters of administration are not obtained, a suit cannot be struck out merely on that account, because the personal representative of a deceased who died intestate will have capacity to sue in respect of the estate to which the deceased is entitled to by operation of the law. The court also went further to say that nothing bars the plaintiff appellant in that case from suing in their names for themselves as beneficiaries of the estate of the deceased, as they have disclosed their interest in the property in question sufficiently. It is thus clear that there's nothing wrong with the applicant in the instance case suing in her name as the sole beneficiary of the claimant. Thus, the submission of the Landed Council on behalf of the defendant that the applicant suing as beneficiary without less of administration is fatal to her case is clearly misconceived. In the same light, the applicant herein, as shown on record via abatement, is the widow of the deceased who died intestate, and she has every right to bring this action against the defendant to recover the benefit of the deceased claimant. By Order 13 rule, concerning rules of this court, it is provided thus, and I quote, no proceedings shall abate by reason of the death or bankruptcy of any of the parties if the cause of action survives the party, unquote. It can be observed that while Order 11 of the rules of this court talks about initiating a case by a beneficiary of a deceased employee, but Order 13 talks about substitution of a deceased litigant. In view of all that has been said, I'm of the view that the applicant's application has merit and is accordingly granted. Yes, Mr. Boilo. Yes. You are muted. Mr. Lawrence, I can't hear you. All of you are muted.
They muted their mic.
Mr. Lawrence Ambelo, you are muted.
Okay.
You are muted.
Hello?
Yeah, Mr. Lawrence.
Yes, can I be?
Yes, I can hear you.
I think we thank the Honorable Court.
Thank you too. Thank you for thanking me.
Well considered ruling, my lord.
Thank you for thanking me.
Yes, my lord.
Yeah, Mr. Boylo.
Yes, my lord. So much. Thank you so much for delivering a well-considered ruling, my lord. If the ruling had otherwise gone the other way, my lord, we would have actually said that the court no longer have eyes and ears to actually see and perceive issues that are actually embedded within parties. But in this case, my lord, we take this well-researched ruling and well-delivered ruling, my lord. Thank you so much.
Thank you so much. Mr. Boylo, what do you do now?
And we also thank my learning land seriously from his position. And we did a date to actually amend our processes. So we take a date for mention so that we can put our house in order and come with yes.
So, Mr. Okon, give us the information.
Mention will suffice, my lord.
Second match.
Mr. Lawrence, is that okay?
Second,
my lord. Second match is actually very convenient. So that
Mr. Boyle, you are not taking is bad. It's cracking.
I don't subject to the confidence of the court. I don't know if you can take 4th of March.
Hello, my lord.
Mr.
Yes.
Lawrence
Yes,
Four.
yes, my lord. Sorry, the network is actually bad on this side, my lord.
Mr.
But
Boyle,
I think the second day of March is convenient to us, by
Which
which
one?
time,
which date, Mr. Boyle?
yes, my lord, it's convenient, my lord.
Which date? Which date?
It's convenient.
The date, which date?
My lord, it's convenient.
Which date?
Which date? Because I'm
It's
suggesting fourth.
convenient, my lord. It's convenient.
Which date is convenient?
It's convenient.
Which date is convenient?
The second day of March is convenient, my lord.
He's saying
The
four.
fourth day of March is convenient.
He's saying
The
four.
fourth day of March is convenient to us, my lord.
Mr. Boyle, he's
Fourth
saying fourth.
day of March. Of March, my lord. Fourth day. The fourth suggested by our, my lord. Yes, my lord. It's convenient, my lord.
Hmm.
This is the devil working.
My lord, he's saying fourth day of March is convenient for him.
Yes.
Thank you so much. Thank you so much. It's convenient. That's the registrar.
So, given the circumstance, cases adjourned to 4/3/2026 formation.
Thank you so much, my lord.
As a copy.
4th March 2026 formation.
As a copy,
As a
please.
copy.
Mr. Lawrence
please.
and
My lord,
Boyle, thank
my
you
lord,
so much. Yes.
I wish you Merry Christmas, my lord.
Thank you. Same to
And
you.
a Happy New Year in advance.
Thank you. Same to you. Thank you so much.
Yes,
Yes,
my lord, even if it is unusual for the court to do Christmas for litigants and lawyers, we will be expecting a very big cow, my lord, especially the one that.
But the thing is that do you have cows in Uyo?
Yes, we do, my lord. Within the Udodoma area, I see some of them grazing over there, my lord.
Okay,
My lord,
okay.
they are available.
Okay. If you want to join us, I will talk to the registry and see how we are going to do it, so that we
I
invite
will be
lawyers.
grateful, my lord.
Okay.
We will be grateful, my lord.
Okay.
Thank you so much, my lord.
But on one condition, if
Go
I
ahead,
be
my lord.
available, because I'll be traveling next week.
Oh. My lord, will give us a proper address, my lord. Where we will come on out.
Okay. Thank you so much.
Thank you so much, my lord.
Thank you. I appreciate that. Thank you.
God bless you, my
Thank
lord.
you. Good afternoon. Thank you.
Earlier.
Because it's going to be, but it's okay.
Mr. Okon. Mr. Okon.
No business with them.
Yes, my lord.
The other case for ex
For
parte
motion.
is the
Okay,
council
my
here?
lord.
Huh?
Yes, they are around, my lord.
Or they're around?
Yes, my lord.
Okay. Okay, you can call the case.
Okay, my lord. Suit number NICNY 28/2025 between Udoide Uta and Afric Delta Marine Limited. Smith Kanalo Nigeria Limited. My lord, party in court.
My lord,
Yes.
the applicant is present.
Okay. Applicant present. Claimant
Yes, my lord.
applicant.
Yes, my lord. My lord,
Ife.
applicant.
Ife.
Defendants absent.
My lord.
I've watched my turn. Yes. I've watched it. All this I've also watched take me out of the.
Yes, my lord.
Yes, defendants absent.
Oh, you don't have
Yes.
it.
Yes.
Yes, my lord, the defendants are absent.
Yes, appearance.
I don't know why.
My lord, Dr. Emmanuel Mbo.
Yes.
My lord, Dr. Emmanuel Mbo with B and with Esquire for the
with who?
For the claimant applicant.
With who?
For the claimant. B and with B and with
okay.
Esquire. BN, my lord, BN is initials. BN.
N.
B and N. Then
as in Nigeria.
NWITE.
As in Nigeria.
NWITE. Yes, my lord. Yes. Yes, my lord.
Okay, for the
W.
What are you doing?
For the claimant.
Yes. Yes. Yes, Dr. Emmanuel, yes.
My lord, we have a motion ex parte before my lord. Yes, sir. My lord, we have a motion ex parte.
Okay. Yes.
Yes, sir. My lord, that motion ex parte was filed on the 15th day of December 2025.
It is filed on the 15th December.
My lord, on 15/12/2025.
Yes. Yes. Yes.
Yes, sir. But my lord, it's brought pursuant to Order 7 rules. Yes, sir. My lord, that motion is brought pursuant to Order 7's Rule 9, 11, and 12 of the rules of this honorable court.
Yes.
Yes, sir. My lord, and sections 97 and 99 of the Sheriff and Civil Process Act.
Okay.
Yes, sir. My lord, the motion is seeking for an order of this honorable court, my lord, granting leave to the claimant applicant to serve the second defendant respondent. My lord, through substituted means.
Yes.
Yes, sir. My lord, by delivering them and pasting the said processes, my lord, at the last known address of the second defendant respondent, and my lord, which is the 5th floor, Foreshore Towers, 2 Osborne Way, Ikoyi, Lagos.
Yes.
Yes, sir. My lord, the second prayer is for an order of this court, my lord, to paste the said process on the notice board of this honorable court.
Yes.
Yes, sir. My lord, the third order is an order of this honorable court, my lord, deeming any of the said processes, any of the said ways, my lord, of the substituted service as proper in the circumstances of this case.
Yes.
Yes, my lord. My lord, in support of this application, my lord, is a 12-paragraph affidavit.
Yes.
My lord, deposed to by the claimant applicant.
Yes.
And my lord, accompanying them is one exhibit marked as Exhibit A, which is the affidavit of non-service.
Yes.
Yes, my lord. My lord, in compliance with the rules of this honorable court, my lord, we have a written address, my lord, which serves as our legal argument in this matter.
Yes.
Yes, my lord. My lord, we urge, my lord, most humbly, my lord, in the interest of justice, fair hearing and expeditious hearing of this suit, my lord, to grant the application as prayed.
Yes.
So that, my lord, the second claimant applicant, the second defendant respondent can be served, my lord, through subsidiary so that we can make progress in the matter. We so urge, my lord, sir.
But this is your prayer too. I don't understand how you want it to be.
My lord, normally, the processes can also be pasted on the notice board of the Honorable Court. My lord, that serves
which
as
court?
a proper service.
If it's
My lord,
pasted
the National Industrial Court.
says
My lord,
what?
the notice board of the National Industrial.
Who says that? Which of our rules, say that somebody can ask an order of the court for social service to be pasted, on the notice board of the court. More especially that the defendant is not even living in located in Uyo, the second defendant. The process will be served in Lagos.
As my lord, as the companies.
So when is pasted on
my lord, let us proceed with the holy prayer. Let us proceed with holy prayer once.
Okay, so upon hearing the motion expatriate dated 11th of December 2025, but filed on the 15th December 2025, it is hereby ordered as follows. Number one, leave is granted to the claimant applicant to serve the second defendant with the originating processes in this suit by substituted means, to which by delivering and pasting same at its last known address located at 5th floor, 4 Shore Towers, 2A Osborne Way, Ikoyi, Lagos. The second prayer is, however, struck out. Accordingly, case remains adjourned to 24th February 2026 for further mention.
As a copy,
It's 23rd.
my lord is 23, not 24, sir.
But in the previous proceeding is 24. Mr. Okon.
All right, it was
Mr. Okon, when was it? You are muted. I can't hear you.
My lord is 23.
Yes, 23.
Yes, my lord.
as a copy. Yes, my lord. My lord is 23 that we have on our record.
From what I recorded, it was 24. And from your endorsement, Mr. Okon, it's okay, 23, because there's even no counsel yet in the no counsel yet in the, so it's 23. Eh?
Okay,
As a
my lord.
copy. As a copy, yes, my lord. Yes, my lord.
Okay. Okay, so I think in the absence of any other thing, that will be all for today, ba?
Yes, my lord.
Dr. Emmanuel and Mr. Unwiche, I wish you good afternoon.
Yes, my lord.
I also wish you.
My lord, thank you very much. And happy compliment of the season, my lord.
Thank you so much. Happy Christmas and New Year in advance.
Thank you, my lord.
Thank you so much. So I leave.
Thank you, sir.
Thank you. So